last Friday, but it was not listed. Even today, it is not listed. So, my lord, I want to be taken it as unlisted today.
Unlisted.
Yes.
Why?
Because my college fund is sought to be taken to to another school by the
Your-
MLA due to their personal rivalry. Very urgent matter, man.
No, Wednesday we'll have it. 29th.
Well, in the meanwhile, fund may be diverted. That is why some
Fund
advice
to be diverted by whom?
by the DC Bongaigaon and the local MLA.
If it is diverted, we will restore it, don't worry. 29th. We'll have it on 29th. Right?
Make legal lawsuit, let the matter be listed for withdrawal.
Withdrawal tomorrow.
My lord, these matters are for admission, my lord. This is for non-sanction of maternity leave, my lord.
Maternity leave. When was it last listed?
It was last listed, my lord. This is the date, my lord. It was listed 4 weeks. This one. It was supposed to be listed after 2 weeks, but it was not
It was
listed.
12th August.
Wait till the lordship. Lordship, the concern council to the other side, lordship. I would mention item number 70. 70.
70.
Lordship, in this matter, there was a direction to produce the record, lordship, proceeding record. Although I have received the scanned copy of the proceeding record, lordship, but I couldn't go through it. So may I prefer listing this matter on 30th 30?
70. Item 70 on the request made by the council appearing for elementary education.
Elementary.
Mr. P.R. Sharma. The reports called for have been received. We praise for relisting the matter on some other date. Released again on 6th of August.
Lordship, the petitioner is retiring on 31st of July, Lordship.
We can't have it on 30th July. Our boards are filled up.
Can it be on 31st also? Retiring on 31st also.
The matter is reset today. Why are you praying for an adjournment and asking it to go on 30th? You are agreeing to prayer made. We'll take it up today.
Lordship, I could go through the record.
You go through it now. We'll take it up.
In that case, lordship, I take up at 2 o'clock.
Lordship, they take up on 6th then, Lordship. 6th.
6th. 6th.
6th?
6th of August.
6th of August. What will happen to his retirement? All right, 6th.
Lovely.
May I please the Lordship? Lordship, may I please beg to mention item 18?
1 minute. Yes,
Lordship, may I please beg to mention item 18.18?
yes.
If you're best.
No, 1-8 for what?
Sorry, Lordship, my learned senior counsel, due to some personal inconvenience, is not here.
Item 18 on the request made on the council for the petitioner stands deferred.
If you're blessed, Lordship.
Wait, with the Lordship, I beg to mention item number 7 and 8. It's a motion with the Lordship. There are certain developments in this case, and then we have to seek
7 and 8 on the request made of the council for the petitioner stands deferred to be listed after 2 weeks.
I beg to mention item 88.
88.
In this case, we need to file reply looking again the affidavit in
88 on the request made by the council for the petitioner stands deferred to be listed after 4 weeks, enabling him to file a rejoinder affidavit. The affidavit filed with the petitioner.
Lordship, I beg to mention item number 79, Lordship. We have taken consent from the opposite party.
79.
79, Lordship.
79 on the consent the request made by the council for the petitioner stands deferred.
And the 28 also, they have filed item number 28.
So
There is
28.
item
Listed
respondent
after
already filed their
after
affidavit.
2 weeks. 28. And 79.
A date may be fixed on this 28. Lordship.
Please, your lordship. Lordship, I beg to mention for listing of one application for admission.
For admission, matter be listed 10th of August.
For blessed, lordship.
Yes.
Lordship, I beg to mention an urgent matter for listing on 28th of July. That is.
What is the urgency?
My Lordship, it is a student's matter. The petitioners, they have completed their mandatory internship, but even after the completion, they have denied the issuance of the certificates. The certificates are necessary for filing the, fill upping the PG entries.
This matter is for admission.
Yes.
When was it last listed?
No, it's a fresh matter.
Fresh matter, motion. All right, 29th.
Highly object. Let to mention lordship item number 5 below. I am seeking for a lordship short adjournment in this matter.
Item 5 on the request made by the council to the petitioner stands referred to be listed after 1 week.
Okay, please, your lordship, I beg to mention item number 71, lordship. Lordship, we have received our instructions, kindly sometime will given for filer affidavit, lordship.
This is for the petitioner.
The concern has been.
Yes? No objection.
Lots of objection.
71 on the request made by the council to the respondent stands deferred to be listed after 3 weeks, enabling them to file their objections. Pray may be the law.
I don't know.
I'm praying for listing of fresh IA for modification of an order, Lordship.
Fresh I 29.
Much obliged.
Please, your lordship, I beg to mention for listing of a matter for admission.
Admission matter. When was it last listed?
Lordship, it was last listed on
10th of August.
Mr. Lordship, with the consent of the other side, I beg to mention item number 23, your lordship. Lordship may
23.
kindly pass over the matter for the day, your lordship.
23 on the request made by the council for respondents.
Respondents.
A date may be given.
The passed over for stands adjourned for 1 week. Relist after 1 week.
Lordship, I beg to mention for listing this matter for admission. It on 21, your lordship, it was one.
21st.
But 21st July, matter came, your lordship. On that day, about
10th August.
on can it be on any hearing day? Your lordship?
Hearing day. Pleadings are exchanged.
Exchange on 11th.
All right, 11.
Similar prayer for another on 11th.
No. First you tell us whether the pleadings are exchanged.
In both the matter pleadings are
All right, 13th August.
one on 11 and one.
Why?
Because your lordship, there is some urgency in one matter. Because your lordship, my service has been terminated on the basis
Let it be on 13, both the matters.
of my
13 August.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention items 80, 81 and 80. The conducting council is suffering from viral fever and as such it could not be.
80, 81, 82.
Yes, sir. Lordship, I
And the request made on behalf of the council to the petitioner stands deferred to be listed after 3 weeks.
Lordship, can it be fixed on 31st?
No, I said 3 weeks.
Urgency, yes, sir.
Urgency. You're for the respondent.
Yes, sir.
The council for respondent. Matter stands deferred to be listed after 2 weeks. 17th August.
First week of August.
I said 2 weeks. 17th. Yes.
May it please your lordship. Lordship, I beg to mention for listing of a contempt petition for orders, lordship.
Orders. Fresh matter.
No, lordship.
5th August.
August,
May it
lordship.
please your Lordship. Lordship, I beg to mention an item for listing in the motion column. 29th.
When was it filed?
Lordship, it was filed on 26th,
Not listed.
not listed. 29th, madam.
29th.
Deeply obliged.
Should I recommend the listing one idea for correction of the order?
Correct, so no. 31st.
No, sir.
Third, council for parties should notice return in 4 weeks. Steps on the respondents. Who are the respondents here? The railways. Anyone for the railways? CGC? Steps on the railways, respondents by speed post within 1 week.
No, that's. Lordship, item number 2 is.
Similar.
Yes,
Railways.
lordship. Railways.
All right, same order. Order at page 13. Third, council for parties issued notice. steps on respondent within 1 week.
So testing will be. Testing will be done.
Dusty. Petitioner is also permitted to take service by giving dusty on the respondents.
Wait,
Yes.
order is at page 24. Related paragraph 20, page 35.
20 page 35.
Page 35, paragraph 20.
Third council. From the respondent by speed post. You also want to take dusty
No,
within 1
wait
week.
for a date when the window is running for family pension.
Let's. Five is the journal. 5, 6.
Directed cases possible 6 on 24th, minor possible notice on 24th.
24th of August.
August.
Third council by party issue notice written in 4 weeks. MSS Sutia appeals for. Respondent number.
So 1, 2, 3. And 5, madam.
1, 2, 3.
1, 2, and 3, madam.
1, 2, and 3.
3.
Mr. Hatuli appears for. Respondent 4. MS is one for respondent number 5. Since the respondent is a representative, notices are waived, extra copies be furnished within a period of 1 week from date. It is submitted at the bar that similar matters are fixed on 24th of August. Accordingly, let this matter be listed again on 24th along with WPC
3518-2026.
3518
2026.
3518-2026. Yes.
What's the time of password for a time?
Time being. Why?
The prisoner is on that.
Time being.
Problems.
Yes.
The prayer of the petitioner is already allowed by the respondent.
It is submitted by the council to the petitioner that the grievances of the writ petition are redressed by the respondents pursuant to filing the writ petition. Therefore, the writ petitioner does not wish to press the petition any further. Accordingly, writ petition stands dismissed as not pressed. Needless to say, if any of his claims survives, writ petitioner is given liberty to approach the court.
Deeply obliged.
Exposed. Yes.
Made these if I am appearing on behalf of Mr. P. Bodler in this matter. Lordship, as per last order, Your Lordship.
Who is the respondent here?
Lordship,
NC Hills.
Yes. They were supposed to bring instructions.
Yes, NC Hills
Lordship,
instructions.
Instructions received, Lordship. As per the instructions which I have received, the petitioner, he has not been terminated, dismissed, or removed from his job. Regarding the prayer for consideration, it has already been forwarded to the inspector of school, waiting for his instruction.
Where is he posted now?
Lordship, he has been released from the council.
Ah.
It's a transferable job, Lordship. Moreover, Lordship, similar matters are taken on 5th of August, Lordship. Let this matter be come up with.
No, that will come, but we want to know, he's
Sorry.
released, he's supposed to go and join where?
No, that state government will have to,
His original parent department was what?
state government,
I know which department,
education.
education department. Yes, education,
Lordship, you will find the appointment order at page 18, Your Lordship, of the writ petition. Was issued by Inspector of Schools, Bima Hasan. The respondent number 3. The initial order of appointment.
He is appointed by your inspector of
Yes,
schools.
yes, Lordship. He is being appointed by our inspector of schools, but his service is being transferable service, Lordship.
So that's what we are asking him. Where have we transferred him?
No, right. That is being under consideration, Lordship, means where he will be.
Your instruction says he is not terminated, dismissed, or removed,
Yes, Lordship.
right?
Yes, Lordship.
So he is only been transferred.
Yes, Lordship.
Transferred to which office? Under which order? Your order says he's released from service.
And the entire autonomous council will
Continue her service in the same place of posting was addressed to inspector of schools. Lordship, the same is pending. If Lordship kindly peruse the next paragraph, Lordship.
Heard learned counsel of the parties,
Lordship,
Mr. Naren Das appears for the council, NCC, so council, MSP, for you are assisting. The petitioner is aggrieved by the impugned order dated 8th of July.
Yes, sir. That is the order.
By 2026, by this order, the petitioner was released from the disposal of North Kachar Hills Autonomous Council, Haflong, for her posting elsewhere. So it is the submission of the writ petitioner that the petitioner's new place of posting has not been given, therefore he has been, it is the apprehension of the petitioner, he has been terminated from service without following the norms. So, Learned counsel of the petitioner has drawn the attention of the court. The order dated 15/2/2026. Sorry, 15/2/2020. Is it 15/2?
Yes, sir.
15/2/2020, by which the petitioner, along with other similar candidates, was appointed. Petitioner's name appears in serial number 5.
Oh, sorry. 5.
5. No, not 5.
5.
Huh?
5. At page 18.
Appears in serial number 5, and whereby she was posted at the government girls higher secondary school in a grade 4 post. Since then, the petitioner has been working there. By the impugned order, petitioner has been released, but her posting has not been granted. So, as the petitioner apprehends that her services may be terminated, then the matter was listed on 22/7/26. The standing council was permitted to obtain instructions. Whereas standing council today has placed before the court the instructions received, which states that they were received by way of communication dated 24th of July. Stop according to the instructions received. The petitioner has not been terminated, dismissed, or removed from service by the impugned order. It merely states that her services are no longer required under the council, and she has been released from the disposal of the council. So, the pointed query by the court as to where her next posting will be, as the impugned order does not reflect the place of posting. The standing council submits that on instructions received that she has merely been released from the NC Hills, from this disposal. She has been released from the disposal of NC Hills Autonomous Council, and now her posting will have to be given by the Department of Education, State of Assam. Having heard counsel of the petitioner by the parties, it is seen that the petitioner was not on deputation from the government of Assam to the NC Hills store. Petitioner's appointment, the grade 4 post, was issued by order dated 15/12/2020, which is annexure A, page 18. So, the impugned order dated so and so reflects that the petitioner's services have been released from the disposal of the NC Hills Autonomous Council for posting elsewhere. So, however, the next posting, however, our posting is not reflected in the review order. So, fresh orders have been passed regarding our posting. So, such circumstances, the court considers it necessary to issue notice, returnable 4 weeks. Since the respondents are represented by the respective counsel, Mr. R. M. Das, appearing for respondents 1, 5, 1, 4, 4. The respondent is waived, but extra copies be furnished within a period of 1 week. From today. Steps of respondent 5. By speed posts. In the interim, it is provided that till the petitioner's next place of posting is issued specifically by an order passed by the competent authority. Petitioner shall continue to work in her earlier place of posting, which is so and so school. And her service benefits, including a salary, also shall be paid by the authorities concerned. Release this matter again.
5th of August.
If that matter has been stayed, but this matter has been stayed till her posting is not been given by the council. So that and this.
Fifth matter, fifth, there are some other matters.
Fifth, some other matters,
Provided the copy of the order.
that matter has been stayed, Lordship, till 5th. But
They submitted that similar matters are listed before this court. Let this matter be listed on along with WPC 3682 on 2026. Yes.
Deeply. Please, Your Lordship. So we are some physical instructors serving in the normal schools under SCRT. Why not, we have graduate qualifications. However, our names are not included in the gradation list. We had submitted our representations, they have not been considered as yet. The provision list has been finalized. However, we have been left out. In fact,
You're putting the provision final gradation list not published.
it has been published.
The challenge here.
Yes, ma'am.
You should notice.
Come on. So then, sorry.
Yes.
Why not the gradation list is being operated to effect promotions to the next higher post of
What can be done?
Madam,
First, let us
subject
find
to
out.
outcome. Subject to outcome.
Right. Heard Mr. P.D. Nair, City Council, assisted by Mr.
H. Rahman.
H. Roman. The petitioner, M.S. Das, appears for
1 and 2. SCERT is the main party here.
1, 2. Who's for finance? M.S. So for finance. Who is SCERT? It is standing council.
Recorded, Your Lordship.
Huh?
Mr. B. Chaudhary, Your Lordship.
B. Chaudhary.
B. Chaudhary.
B. Chaudhary. Mr. B. Chaudhary appears for respondent 4 and 5. The respondents are represented, notices of waived, extra copy will be furnished within a period of 1 week. Where the challenge made in the writ petition is to the final gradation list of assistant teachers in regular arts and science, instructors from a music teachers, Hindi
Instruction.
teachers,
Okay.
Sanskrit, and graduate instructors.
SCERT.
Under the published by the SCERT. So the petitioners claim to be
The physical instructors.
physical instructors whose names have not been included in the gradation list. They filed their objections when the provisional gradation list was published. However, same was not considered that the impugned final gradation list was published, where the names of the petitioners are not included. So the grievance of the petitioners further are that this final gradation list is being operated to affect promotions to the next higher post. Therefore, petitioners are agreed on the court by filing. But having heard counsel for parties, let the respondents complete their instructions and file necessary affidavit. It is made clear that any further promotion affected to the next higher post on the basis of the impugned relation is dated 17 June 2025 shall be made subject to the outcome of the regulation.
Deeply.
Once again, after written verdict.
Deeply.
Yes.
This is for the appointment of arbitrator, my lord. This case, my lord.
Any hearings? Any objections?
Madam, Lordship has had this matter, madam, we have some judgment also. And madam, our contention is, madam, this is not regarding appointment of arbitrator. This is regarding substitution of arbitrator. Because already
We'll list again on some hearing dates.
13th, my lord. Maybe for
20
August.
August. They submitted that the matter will require some hearing, pleadings are exchanged. The parties will address the court on 008/2026. Yes.
Steps has been taken, my lord, way back on, my lord, 26/3/2021.
Steps taken on
26/3/2021.
21.
21.
So there is an office note on 17/3/26. Lozima Court directed you to take fresh steps that you have not taken. Petitioner permitted 2 weeks time to take fresh steps in terms of the Lozima Court order dated 5/3/2026. Released after 2 weeks.
All right. What if, fresh steps have to be taken? Fresh steps have to be taken.
Counsel for the petitioner prays for and is granted 2 weeks further time to take fresh
Already
steps.
the relief has been granted, so I have to, already the relief there, what they seek was granted. So I need some time to take instruction whether they want to pursue this matter or not.
Relief granted, so close it.
So let me take some instruction. Let
Counsel for the petitioner submits that he would like to complete his instruction. I will be in Malaga, President. As whether whether the petitioner wishes to pursue the matter any further, as it is submitted that relief prayed for has already been granted. Release this matter on 3rd August.
Lordship, I am appearing for respondent number 5.
Mr.
KJ Saikin.
KJ Sokia appears for respondent number
5.
5.
Deeply.
In this matter, I have sent affidavit for vetting, my lord. And our affidavit regarding the maintenance.
Affidavit regarding what? This is a review matter.
Yes, my lord, regarding the maintainability of the review, my lord. Here, my lord, judgment was passed, my lord, on 6/1/2020. But they filed the review petition on 29/5/2024 without explaining the any ground regarding the delay, my lord, in the review petition.
But why affidavit is necessary? As any, you have been permitted to file.
Fine.
Okay. Mr. I. Sokia for the petitioner, Mr. S. U. Sharma for the
Secondary education
secondary
department.
education submits that the affidavit is permitted to be filed, not be filed as the same is
It is sending for vetting, man.
as the same is under preparation. He prays for further 2 weeks time to file his affidavit. let this affidavit be filed within 2 weeks as permitted, failing which court will proceed to hear the matter on the next day.
Yes.
Released again after. Yes.
Contempt application lordship. High Court's judgment is 16/6/23, page 14 lordship start from.
Yeah, sometimes required.
How many times they required lordship on dated 16/6, directed to comply within 3 months.
For what? What direction?
Direction lordship page 27 lordship.
Why can't you tell us what is the direction?
Direction lordship, direction to provincial service of the writ petition.
Provincialize.
Provincialize.
Any appeal file?
No, ma'am.
Then
Time again.
we give you 1 week time to comply. Failing which will issue contempt proceeding, will drop contempt proceedings.
My lord, the director already sent it to placing the matter on next state level scrutiny committee, my lord.
Provincialize.
Yes, my lord.
When is the next date of scrutiny committee? Permitted to be, who is the chairman of the scrutiny committee?
Regarding my lord, the district scrutiny committee, it is the director, it is the district commissioner, my lord. And they have already recommended, my lord.
Huh?
But the recommendation from the state level committee is required, my lord. And matter is under process. And my lord, this is our day-to-day activities regarding.
I have not understood
Yes.
anything you have submitted.
No.
What exactly do you want to say?
May I speak, lordship? Lordship, here the direction was to provincialize the service of petitioner, lordship. Now, for provincialization, that recommendation from the district committee we have received, lordship. Now it has to be placed before the state level committee. Therefore, the director has already forwarded the matter to the secretary, to the government, lordship, to place it before the SLSC. As soon as the SLSC recommend, lordship, his service will provincialize.
When is the SLSC?
That will take some time, lordship.
Who is the chairman of the SLSC?
SLSC, lordship, chairman is the secretary, lordship. It's secretary. Director is himself is the chairman of the secretary.
The director
But
is
the approval has to be taken from the government, lordship.
we don't know, but there is an order. Whatever steps you have to take, you take it. Otherwise, we are issuing contempt notice. No appeal has been filed.
No, because we are considering the case, lordship.
Then you
That's a-
consider it. You
Yes,
can't really take it. It can be for how many years now it is going on? When was the direction issued? 23. 3 years have already gone, and what are you saying that you are considering?
2016/6.
We want compliance within 2 weeks. You get instructions, or we are proceeding against the director.
Yes, sir.
The matter be listed immediately after 2 weeks, by which time the respondent, counsel for the respondent will apprise the court regarding the status of the compliance of the direction of the court's order dated so and so, passed in WP so and so. Stop, it is made clear that if the court is of, if the court finds that the respondents have not taken proper steps for compliance of the court's order, court will proceed to issue notices under the Contempt of Courts Act 1971, read with Gauhati High Court so and so, Contempt of Courts. Deal with this matter immediately after 2 weeks on a date to be fixed by the registry. Mr. Chisti appears for respondent, sole respondent.
Two others. Yes.
Affidavit filed.
But if from the responsive headmaster affidavit filed, but from the side of department no affidavit, so I may be under 10 days time.
None appears for the matter being called. Mr. P.P.
Doctor.
Doctor Council for Secondary Education prays for it is granted 3 weeks further time. Take steps to file appeal. We will stop the 3 weeks.
Last occasion,
Lordship, here we have received our instructions, Lordship. We finance is not a party, Lordship, but we were, Lordship, I have few.
Where is the order?
Lordship, it will be in page 20. The order is page 28, Lordship, I think, the operative part. Operated 1512, yes, page 28. Lordship.
para 14.
That's a concrete time frame.
Lordship, here the issue was we were not party in the writ proceedings. We were not made a party in the contempt proceedings also, Lordship. On the last date, Lordship had informed us. So, Lordship, if in the meantime, if my learned friend can take steps on the current incumbent, in the meantime, Lordship, we can provide an update because it is under consideration. It has just come to their knowledge, Lordship. On the last date only, it has come to their knowledge regarding. So some time may be granted. In the meantime, Lordship, a concrete date. I'll ask for the concrete date when the approval can be given for compliance of this order. Lordship, may accommodate us for 2 weeks at least, Lordship. Because we are not a party, we were not party in the writ proceedings.
Very well. Weeks may be given.
In the meantime, Lordship, since it's a contempt proceeding, my learned friend can implead the Commissioner and Secretary of the Finance Department also, Lordship.
Why don't you take steps? It's at the initiation of the court that the request of the court.
Yes, because Lordship, last occasion, my friend Mr. Bora submitted that the matter has been given to the Finance Department.
Yes, Lordship.
But the Finance Department is now.
Yeah, we have assisted, Lordship.
Mr. Monto appears for the petitioner, Mr. A. Chaliha, Finance, representing the Finance Department, has appeared before the court. Request made by the court. Find out the status would be in respect of the steps taken by the department regarding compliance with the directions contained in the order dated so and so passed in the so and so. Where is the order again? Page 28.
Page 28, Lordship.
The court had requested the Standing Council Finance in the submissions made by the Council for Secondary Education that elementary education, that all necessary papers towards compliance of its courts have been furnished, have been placed before and forwarded to the Finance Department. Released again after 2 weeks. After 2 weeks,
Lordship.
as the finance will apprise the court as to the status of the steps taken.
In the meantime, if they can take steps on the current incumbent, they can implead the Finance Department.
That's their call.
Lordship.
We can be.
Lordship. Okay.
Okay.
20.
last occasion, my lord, the respondents, they were directed to pass an order, my lord, Commissioner Secretary, final order. Matter relates to my lord, payment of interest for delayed payment of pension revenue.
The directorate has asked the college authority madam to submit a report, detailed report madam regarding the delay part madam. Then the college authority has submitted and accordingly madam the directorate has also prepared an report and that report is now sent to the government madam. It's pending in government. May I kindly give madam 2 weeks time madam?
Mr. S. Das, counsel representing the respondent number
1 and 2. 1 and 2 my lord.
1 and 2 submits that the department has taken steps to comply with the directions contained in the order dated so and so, past in so and so, as they prepared a report and which has been forwarded to the respondent number 1's
Madam.
office.
Madam.
Who is for respondent 1?
1 I am checking.
You are appearing. And the final orders on being passed on by respondent 1, the same can be placed in court. He prays for 2 weeks further time. Prayer made is considered and allowed. Released after 2 weeks. Mr. S. Thakur appears for contempt petition. You are appearing for Mr. C. Burwa appears to respond. Matter to be listed after 2 weeks on a date to be fixed by the registry.
So in this case, on the earlier occasion, my colleague Mr. A. Fukan has already submitted a compliance order. Now petitioner, they are supposed to
Yes,
apply
there is
the
the compliance order. Order dated 23rd June.
Yes, sir.
Is the direction here?
Direction to place it before the High Power Committee for regulation. And if the High Power Committee reject it, they can reject it within reason order. If it deny the regulation, then they should pass a reason order. So that was issued, Lordship. And it was found that the report from the Director of Elementary Education, Lordship, regarding the discrepancy regarding authenticity of the appointment records, validity of education qualification, inability to conclusively establish her service status.
No, is it only for disposal?
No, madam.
Kindly read para 16 of the judgment.
Direction was at Lordship, page number 29, paragraph 16.
Para 16.
16, my lord, page number.
There is a finding by the court.
Yes. Para 16.5, Lordship, may kindly last point, Lordship. In the event the High Power Committee of the on exemption.
No. Read. This is quoting the paragraphs of some other case.
Yes.
But the finding of the court in this matter
Yes, sir.
is at para 16.
Lordship.
If you read para 16,
Lordship,
there is a finding.
Today I am in a difficulty because the entire record of witness F1 because of his illness, Lordship, he is unable to come. So record is not with me. I am just submitting this court. Can it take up day after tomorrow, Lordship?
Of the request made by the counsel for the petitioner, matter stands referred to be listed on 31st.
Yes.
Yes.
And on the court's order, Lordship will find at page 23. Portion minor, page 26, para 5. There was 2 orders, man. Earlier there was a petition minor. It was subsequently.
Appeal disposed of.
In this case, Director Elementary has dropped a letter to the concerned secretary about the inquiry reports, this one of inquiry reports. So sometime maybe.
Mr. M. Ali is this for the petitioner and then open appeals for the respondent. Submits that the inquiry and verification report
Yes,
along
ma'am.
with DICE data
Yes,
in connection with the matter, present matter has been furnished from the office of the director to the office of the commissioner and secretary. Matter is presently pending thereon. Council therefore submits that further 4 weeks time be granted
Ma'am.
to apprise the court
process.
and status of the matter. Apprise the court of status of the matter. Considering the submission may released after 4 weeks on a date to be fixed for the registry.
Deeply.
All right.
Please, Lord.
Yes.
Lordship here, the state has been taken, but the DLC has not been held. Lordship, may kindly grant us some time.
Our court has directed the respondent authorities to place the case of the petitioner for the next DLC lordship.
It has not been placed.
Lordship, the DLC has yet to be held.
Yet to be held is not a ground. Court has given you a fixed time to place it within 3 months.
Lordship, the department has taken steps in order to place before the DLC.
You inform your clients that if by the next date, if this compliance is not there, we are drawing up contempt proceedings. This order was passed on 15/9/25. You are given 3 months time. It's going to be 1 year after a month or so.
They have forwarded for pre-approval before placing it before.
We
DLC.
don't know what steps you are taking, before which authority you are placing. You have not prayed for enlargement of time for compliance. You have not filed an appeal or a review. The order remains. The order has to be complied with. Counsel for the respondent is permitted 3 weeks time to complete his instructions in regard to the directions contained in the order dated so and so, passed in WPC so and so. If the instructions as sought to be, as permitted to be brought before the court are not available, then the court may proceed to initiate proceedings under the Contempt of Courts Act 1970. Mr.
A. Alim Sheikh, Lordship, kindly date.
A. Alim Sheikh appears for the writ petition. Yes,
Lordship, kindly date me.
matter be listed on a date to be fixed by the registry after 3 weeks.
I'll go.
Yes.
Lordship, as per my instruction, Lordship, in connection with shifting of SKFZ High School, Lordship District Sribhumi is hereby kept in abeyance until further order. This is the instruction I have received from the director of state.
Wait. What is the IA for?
Again, one of the interim, kindly see the interim order, my lord, page 62 of my EMI,
62.
page 62. That is shifting of a school.
Shifting over school.
That is a resolution by the managing committee. Then my lord, matter went to inspector, school director, etc. Thereafter, this order was passed. After thorough inquiry, after taking into consideration all the my lord, facts and figures.
You are for the respondent,
Yes, my lord.
headmaster.
Headmaster. My lord, kindly come to page, my lord. Initially, there was a resolution by the managing committee. That was forwarded to the director, my lord, to IA. Page 23 start, my. Resolution is page 17.
Yes, so what was the direction here?
Yes, your kindly see page 23 start. Then imping order that they have treated my lord is pay. Yes, page 60, my. That is the
60.
understanding. That is it.
So the petitioner,
I,
now you are seeking a vacation of these,
yes, ma'am.
this.
Or should we be pleased to hear the interlocutory application or the entire matter together? The same thing.
What is the challenge in the writ
My-
petition? Let us understand.
Yes, that page 66.
60. On what ground are you challenging it?
My lordship.
What? On what ground you are challenging?
My lord, so far as the present interim order is concerned, if I may invite my lord's attention to the appeal order, my lord.
What order?
The order which we have challenged in the writ petition, page 17,
Yes.
17.
Yes.
May I read that?
Yes.
The proposal for shifting of SKFJ High School to the newly proposed land of Fatehpur under Sribhumi district, submitted by the Inspector of Schools Sribhumi, vide his letter number so and so dated 18/7/25 and so and so dated 11/2/26, and resolution of the managing committee, guardians of the school under Sribhumi district is hereby approved. If my lord would have, we have submitted the list of books. The Assam Education, Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017 for a moment. In the compilation, my lord, it will be there at page 99 in the education manual.
Mr. Senior Counsel. Here you are not challenging the shifting.
No, I am for shifting, man.
You're for shifting.
Yes. Already it is already done, shifted also, man, 50% shifted.
You are opposing the shifting.
So I'll address purely on the law. If the law is against me, they will succeed. If it is not, it cannot be shifted. Well, page 99, that act will.
99, yes.
I will invite my lord's attention to section 12.
Well,
That's at page 119.
119,
May I read that?
yes.
Amalgamation, merger, and shifting or expansion of educational institutions. 1. In appropriate cases, if there is already an existing educational institution nearby and the enrollment of the students do not justify for more than one institution in the same locality, or there are other sufficient reasons to do so, the state government, in the public interest and for reasons to be recorded in writing, may order for transfer or shifting of the institution and the incumbents of the institution from one place to another, or may order amalgamation or merger of two or more existing institutions as per Shiksha Kshetra scheme. Second is the expansion. In appropriate cases, if the state government is of the view that an existing education institution needs to be expanded so as to have more classes, the state government may, by order, make an expansion of an existing educational institution from primary to upper primary and from upper primary to secondary and secondary to higher secondary, or reverse the state education institutions to a lower level and in the case of loose or absence of such necessity of such more classes in any such education institutions. All incumbents whose services have been provincialized under the provisions of this Act and who are working in one or the schools in respect of which an order under subsection 1 or 2 has been passed shall be liable to be transferred and posted in any other provincialized institution in the same rank and grade. all teachers working in higher grade in an institution in respect of which an order under subsection 2 has been passed may be required to teach in the lower classes also. Subsection 1 would require a precondition or set of preconditions to be satisfied and an action to be taken by the state government in the public interest and for the reasons to be recorded in writing.
This is not a subsection 1 matter.
It would be.
Why?
Because
The order says for newly proposed land.
absolutely, I'll address that.
Oh.
The proposal for shifting,
Oh.
here is shifting the so-and-so school to a newly proposed land. Of course, shifting would be from ABCD to EFGH. So that would be the newly proposed land. Here it says, in appropriate cases, if there is already an existing education institution nearby and the enrollment of the students do not justify for more than one institution in the same locality, or there are some other sufficient reasons to do so, the state government in the public interest and for the reasons recorded in writing may order for transfer or shifting of the institution. Essentially, it is a shifting from place A to place B.
No, why not 2?
My lordships.
Why not subsection 2?
Then both would exist, you know. In appropriate cases, if the state government is of the view that an existing education institution needs to be expanded as to have more classes, the state government may by order make an expansion of an existing education institution from, this is primary to upper primary.
Okay.
Upper, that is different, you know. So essentially, when a shifting has to be done of a provincialized school, now we were a madrasa, we lost the status after the bill came in 2020 and the act came in 21. We fall back on the school level. Therefore, for amalgamation, merger, shifting, or expansion, as the case may be, the preconditions of section 12 have to be satisfied. Now, the impugned order, you know, it proceeds on an approval granted by the Director of Secondary Education. On what? And proposal submitted by the Inspector of Schools and the resolution of the Managing Committee and guardians.
This you are reading from where?
The page 17, I'm reading page 17 of the writ petition.
17.
So this, on the act would say different, public interest and reasons recorded in writing. It's absolutely a move to be stemmed out on the individual and thinking of the government that yes, we require 12.1 or 12.2. Here it says a proposal is mooted by the Inspector of Schools, rightly or wrongly, and the Managing Committee guardian, there's a resolution which is approved. So this is not the manner and method in which, all respect, in which a shifting of a provincialized school takes place. Number one. Number two, if I may invite my attention to the interlocutory application file for vacation,
That's 12.1 and the impugned order which is passed do not appear to be in sync. The 12.1 is for something else.
12.1 is shifting. May I read again very slowly? In appropriate cases, if there is already an existing educational institution nearby, first condition. And
First, let us understand what is the reason for transfer.
They're shifting.
Shifting.
They say this will be lowland. We cannot continue here. There is another school also nearby. So we resolve to move to new place. The headmaster says so, and all others think so. They have a meeting. That meeting is also bad, and we'll come to that. But here the law says, in appropriate cases, if there is already an existing educational institution nearby, and the enrollment of the students do not justify for more than one institution in the same locality, or there are other sufficient reasons to do so, the state government, in the public interest and for the reasons to be recorded in writing, may order for transfer or shifting of the institution and the incumbents of the institution from one place to another, or may order amalgamation or merger of two or more existing institutions as per Shiksha Kshetra scheme. So when we understand the concept of shifting in terms of section 12, it needs an independent exercise by the state government for the prior conditions to be met and for the reasons to be recorded in writing. This was patently absent in the order at page 17, which perhaps my friend has said that presently is kept in abeyance.
So this order was passed ex parte. It was
yes, my
interim order was passed ex parte.
Yes, but then we filed the vacation petition on P626.
Secondly,
what is the provision for shifting of the school? Is it this particular provision referred, or is there any other provision?
Actually, in fact, section 12, man, this act is not applicable in our case, man. The very act of 17, it is for provincialization of the venture schools. And the teachers to venture in schools, sort of mind. Not the provincialized one, mind. Our school was provincial in 2013. Then it was a madrasa, mind. It was converted to a school in 2021. It was converted. Now, by the particular place where the original school was there, another school, they are having in my enrollment.
Show us the provision from whatever rules or statute as to what is the procedure prescribed for shifting.
That is what we do not find except this one.
You do not find, then from where did you get the authority to shift a school from X place to Y place?
Because the difficulty they have explained that my lord.
These difficulties are not, where are the difficulties expressed?
My lord, ultimately, your loss can is resolution, MC resolution.
Is the managing committee so powerful that it can take any resolution?
No,
to
managing
shift a
committee
school
propose,
from
just
A to
given a
B?
proposal to the inspector. Inspector
Where is
has
the
given to
resolution?
the director, man.
Where is the resolution?
Yes, the loss can. So your loss would find, kindly take my IA, my
IA?
IA. Solution is page 17. That was page 17 English. One o'clock is also enforced.
But there must be a provision. You can't just shift a school like that.
But then it was inquired into my next page 23 you look at it, on one. Page 23 on one.
23.
Page 23 on one, man. 23 is a letter from the inspector of school to the director regarding shifting this resolution. With reference to the subject above, I have the honor to state that South Korean so and so has been converted to high school. The name of the student so and so. The school is situated in a remote corner of the district, and this area where the school is situated is very much communicational backward. SMDC of the school adopted a resolution in its meeting letter so and so to the school nearby road. Guardian, Odisha teaching staff also requested to attend the school. The land upon which the school will be shifted would also be donated in the name of the school. This was then on the next day, page 25. This letter from joint director to the inspector. He said in this regard, you are requested to submit the
No,
following.
these are not what we want to know. We want to know where is the provision which permits shifting of a school or permits the managing committee to take a decision on whatever
That
grounds.
part
And
by
then
not
file
except
it.
this 12, we do not find anywhere except this 12 in this act.
Then you say this act
That-
doesn't apply to you.
Why not? No, I say that if this act is also take, this is not applicable in our case. Since we bench education.
And what is the state's view on this?
And so far as the applicability of the act is concerned, well, it is applicable and we can show it from the provision.
What is the state, where is the reasons for shifting, transfer?
Page 25, 27, 28.
As of
PW.
Lordship, I do not have any instruction
You
in
don't,
details, Lordship.
you don't have any.
Lordship. I'll need more elaboration.
Let them get their instruction.
Lordship.
But in the meantime, madam,
Who's appearing for respondent 5? You are appearing. Respondent 5 in the writ petition.
yeah, but they have the signature also. Peter Bhawan, the president, his signature to the resolution.
No signatory, no signatory,
Madam,
decision.
madam,
But
respondent five.
where does one
Respondent 5.
who's respondent 5?
I am appearing, headmaster.
Headmaster. You have been implemented subsequently.
No, we have made party also. Now they have filed an application, my lord, my learned friend went.
Who are you? For the time being, we'll keep it like that. Let us see. Get the instructions. Tell us under what provision you have allowed the shifting.
If you also go through these papers, I am not saying that about the procedure.
No,
Procedure,
there are two things. One
Yeah.
is whether the proper sanction has been obtained. You are addressing the court that proper sanction is there. But where is the source of the power? Under what provision is it being done?
that might not be.
Where is the power given to the managing committee to take a decision? that we want to shift from place X to place Y.
Whole question is matter this is calm. The money committee pastor is requesting the authority to look into the matter whether this institution can money exists there or not. On that basis, matter everything is mooted. Director level, matter inspector level.
What under what
They
provision?
made only a request for the since in their school, in this school, but the very difficulty for the students matter to attend the school. That's what it is.
Why?
But because of this report your lordship said, before the engineer, before the IS, the report,
Let the state get the information. Let us.
Lordship,
why not only question is why not question of students. Some of them already shifted, 2 or 3 might have teachers remain there. Now they
When can you get it?
get the
4 weeks of time, Lordship.
4 weeks.
which
There is an interim order.
Lordship.
How can it
At
be?
least Lordship may allow me 2 weeks of time.
No, next week. There is an interim order. We have to see whether to continue or vacate the interim order. An interim order suspending the order passed by the director.
Lordship.
You get it by next week.
Lord.
All right, 10th. Let us have it on 10th of August.
can,
Lordship.
with 2 weeks. It will be. Almost.
You are the one filing vacating of the interim order.
So that's why I'm in urgent, people might have.
We were giving you 10th. You said no, let it be after 2 weeks.
No, I'm not saying. They asked for 2 weeks. And it ultimately it becomes 2 weeks, man. Something might become very urgent matter, that's why, man.
How can it become 2 weeks?
10th of
Today it
August.
is 27th. 27th. We are
Fourth.
fixing the matter on 10th only.
10th of August.
Instead of 7th, we are
Can
doing
it
it
be-
on 10th.
7.
10th of August.
7th. All right, 7th.
7, man.
Mr. H.R.A. Chaudhary, Senior Advocate, assisted by Mr. F.U. Borguia, appears for the applicant in WPC 2090-2026 as also respondent number 5. Mr. Manik, Senior Counsel, assisted by Mr. appears for the writ petitioner, and Ms. Sharma appears for the state.
Lordship. 1, 2, and 4.
The respondent 5 is filed the IA seeking vacation of the interim order dated so and so, passed in WPC so and so. Stop. The state respondents are not posted with the required instructions as to the basis on which the impugned order was passed by the director permitting the shifting of the school. And the relevant rules or instructions. Relevant rules or notifications of office memorandum, basis of which the same is permissible. Let these instructions be placed before the court on the next date, 7th of August. 7th of August. Mr. M. Khan appears in IA number 090, seeking impleadment. This IA be also listed along with WPC so and so and IA number 2615 on 7th of August. The interim order. Interim orders, many will continue till the next date of listing.
The matter is fixed for consideration of my interim preamble. Also, the petitioner also, she was initially appointed as a regular principal in 2017. But before I could join Lordship, one Sarlota Kolta Lordship challenged my selection and appointment and obtained a stay order, and I could not join. And she continued as the in-charge principal. The writ petition was finally dismissed. But before my restoration order came, Lordship, she again filed a writ appeal. And in the writ appeal, Lordship, the division bench directed selection and appointment of the petitioner was passed, and there was a direction to conduct a fresh selection within a period of 3 months. That order was passed in the year 2023. I submitted the certified copy, also submitted my representation also. Now, Lordship, they did not act it, Lordship. Although there was some process, but Lordship, the selection was not conducted. Now, Lordship, there is a fresh move for a regular selection of principal. There was a specific direction to conduct the selection as per Rule 8.4.
Where is that
Lordship,
direction?
Division bench order, Lordship, may kindly see at this.
Yes,
The direction at page 56, Lordship.
56. Fresh selection.
Fresh selection in terms of Rule 8(4) of the Assam Secondary Education Provincial Service Rules 2003 and hold fresh selection for the post of principal. Because there is a controversy with regard to constitution of the school selection process.
Who was the appellant?
Appellant was Lordship once Harluda Kolta.
So the appellant has continued in
Continued
the post.
and she also got retired. Now thereafter also I was appointed as the in-charge principal. Now this exercise has not been carried out also.
Yes.
Here instruction is awaiting matter. So sometime maybe.
What interim orders you want?
Lordship, this post should be kept outside the purview of the fresh selection process.
Why?
Because Lordship, they will hold the selection as per the new rules. Lordship.
Exactly. That is what the direction is.
No, that is no.
8(4).
No, direction was to conduct the selection as per Rule 8(4) of the Assam Secondary Education Provincial Service Rule 2003.
Ah.
2003.
And what is the new rule?
New rule will be also 2018. That will be a district-wise lawsuit. That will take a lot of time loss.
We don't know the direction of the division bench is 2003.
2003 rules. Yes.
You wanted to be conducted under which rule?
2003 rules.
2003 rules.
Lawsuit.
Then why should it be kept outside the purview?
Purview from the fresh selection process of 2018. Lawsuit. There is now a fresh move for a fresh selection process of regular principal. That lawsuit, that advertisement lawsuit I have annexed.
Heard Mr. S. Is it under challenge? Advertisement is under challenge.
No, lawsuit, I have only paid for to conduct the selection as per 2003 service rule as per the division bench order.
You've not filed a contempt.
No, lawsuit, there was some delay lawsuit. Since there was some process lawsuit, I could not file the contempt lawsuit. In the meanwhile,
Mr. S. Das, learned counsel, appears for the petitioner. Mr. Q. Sharma appears for the respondent.
Your Lordship,
Respondent number
123, madam.
1, 2, and 3.
Your Lordship, I appear for respondent number 4 and 5.
Your name?
M.R. Bharali. I have filed my Wakalatama during the course of the day.
Today.
Yes.
Mr. M.R. Bharali appears for respondent 4 and 5, who submits that he has received instructions to appear in the writ petition today and has filed his power. Stop. The petitioner had earlier been the petitioner was aggrieved by the selection of the private respondent number.
no, there's no private respondent.
There is no private respondent. Was aggrieved by the selection of.
Lordship, I was selected as a regular principal,
Achha.
but I could not join lawsuit.
Petitioner was earlier selected as a regular principal of which school?
AKHS institution, not Gauhati.
AK?
AKHS institution, not Gauhati.
AKAH institution,
Not Gauhati.
not Gauhati. Stop. Petitioner, however, could not join. Why you could not join?
Because lawsuit, there's an interim order passed by lawsuit the single judge. Initially lawsuit, once Harloda Kolta challenged the selection on the basis of the constitution of the school selection.
As there was an interim order operating at the relevant point in time, on the basis of the writ petition filed by one of the candidates, well, also applied for the selection but selected. So, the writ petition filed by the said candidate ultimately came to be disposed of
On 25/1/2009.
on
25/1/2009.
25/1/2019, passed in WPC, total 5 of 2017. Then the writ petition was accordingly dismissed. Being aggrieved, the said candidate filed a writ appeal, being writ appeal number 36 of 2019. Stop. This writ appeal came to be disposed of by the orders of the division bench, and the following directions were issued. There are 13 onwards, page numbers 55, 6. Stop. Para pursuant to the said directions, the appellant therein continued as in the post of principal of so institution in the interim measure and subsequently debited her office on
Lordship, Chairman,
Subsequently demitted her office stock pursuant to her superannuation. Present writ petitioner has been given responsibility as an in-charge principal of the said institution. Stop. The limited grievance of the writ petitioner is that the state has not taken steps in terms of the clear directions given by the appellate court in writ appeal number so and so in terms of para 15 said order. Stop. According to the writ petitioner, the state was directed to constitute a fresh school selection committee in strict compliance to the requirements of Rule 8.4 of the Assam Secondary Education Provincialized Service Rules 2003 and whole fresh selection for the post of principal AKHS institution, and the said exercise was directed to be conducted in 3 months. Notwithstanding the said order being an inter-party order, and notwithstanding the same being brought to the notice of the respondent state, the said process has not been initiated. Instead, the petitioners are now contemplating initiate the selection in terms of the what routes?
General Advertisement Lordship 5/6 2026. 2018 course.
In terms of the some secondary education provincialized service rules 2018, read with its amendment of 2021. So the petitioner apprehends that this process has already been undertaken by the advertisement dated 5/6/26, passed in advertisement issued in the Assam Tribune. So it is the apprehension of the writ petitioner that notwithstanding the order passed with the division bench by way of judgment and order dated so and so, passed in writ appeal so and so, steps are being taken by the state to fill up the post, the present school, contrary to the directions of the writ appellate court and in terms of the rules of 2018, read with the amendment of 2021. Being agreed, the present writ petition has been filed. Mr. Sharma does not have any instructions in the matter. Is there any SLP filed or anything filed against this? You don't have any instructions? Mr. Sharma will therefore obtain the instructions from the respondent state as to the status of compliance of the status as to whether the state is proceeding to fill up the post of principal in so and so institution where the petitioner is holding charge as in charge principal in terms of the directions contained in the order dated so and so, passed in writ appeal number so and so, or in terms of the rules of 2018 read with its amendment. Then these instructions will be placed before the court on 14th August. In the meanwhile, without till the next returnable date, no steps be taken to fill up the post in which the writ petitioner is presently serving as the charge, other than by way of the directions contained in the order dated so and so, passed in writ appeal numbers. And until such steps are taken, petitioner also may be permitted to continue in our present status of service. Yes.
Can we consider order dated 25/2020 last one? Supposed to be the area salary, the retired profession.
Proceedings are complete. Affidavit not filed.
On affidavit not filed, because the claim of the petitioner is regarding his area salary matter. That was verified by the director of office. Now it has been sent to the.
Is he entitled or not?
As per my instruction, the director is found entitled. Now it has to be
Mr. S. not for the petitioner, Mr. S. Das for the state education department submits that an inquiry was conducted by the director regarding the claims of the area salary of the petitioner. And the report is presently submitted to the office of the secretary of the school education department.
But due to non-allocation of budget, it could not be sent to the government.
However, conducted by the director, however, because of non-allocation of budget, the said proposal will be sent to the office of the secretary of school education,
Higher division.
higher education. Stop. When will the budget be allocated?
On 23rd, this assembly will complete. After that, I think. But only 3 weeks may be given.
The counsel for the petitioner submits that he be permitted instructions and prays for 3 weeks' time. MS or Pujari appears for UGC. Released again after 3 weeks, the date to be fixed by the registry. Date will be given by the registry after 3 weeks. What are these matters?
In this, there were 2 instruction placement. In last order, your lordship has recorded. Against one of the petitioner, I have got a clarification, but rest of the petitioner, I need some more time.
Your claims are that, their claims are that you were not appointed against sanction vacant posts. Yes? Now what?
Now,
No, not that.
in respect
We are
of
working since long back in the year 1994 against the sanction vacant post for the period of 3 months, 4 months like that. Then they have passed order for until further order. Madam. Then since we are not regularized, then we approached before this honorable court. Then honorable court passed an order to regularize the services of the petitioners. Umadevi's case, under the Umadevi's case. Then they have filed after 4-5 years, my lord, they have filed instead of provincialization of our services, my lord, they have filed review. In the review, my lord, it is stated by this honorable court only one point part that allowed that they should appear, petitioners should appear before the commissioner and secretary and place the their appointment, original appointment orders. If they have been working against the sanction vacant post, then their service has been regularized. That is the case. Now they, what happened? Then they make a committee, madam, where there is no order like that. Then against that committee we have come, because in committee they make a committee, but there is no order in this in that review petition.
that only the point is that, my lord, they will appear before the commissioner and secretary and place the original appointment letter. And if appointment letter shows that we are working against the sanctioned vacant post, then our services will be requisite. Am I correct? Now they have said that we are working as a sanctioned vacant post. Of course, not all, my lord. Some of the candidates, petitioners, like Jiten Guhai, it is stated that they have been, he has been working as sanctioned vacant post.
So here in this repetition, the challenge has been made to the order, that is at page 184. Operative portion of the order is at page 186.
My lord, lordship is taking up item 29. My lord, I think 29 order is in item number 30, 10-6-26.
Okay.
Item 39 appearing on
Page 21. Page 121. Speaking order, my lord.
10-6-26, my lord, the education department had submitted, my lord, the name of 10-6-26.
10-6-26,
26.
page number.
Order.
No, order passed by this honorable
Yes,
board.
item 30.
30. In case of item number 30.
10-6-26.
Yes, my lord. Jiten Guhai, Onil Chandra Gayer, Hiranya Das. Instruction have been received that they were appointed against the sanction post. However, sanctions are still awaited with regards to the information in respect of the other petitioner. He further submits that the instruction are to be verified by the director.
So,
The remaining fives are not placed before this honorable
Okay.
court, that whether they have been working as a sanction vacant post or not.
what happens to the other, these three?
Or in respect of serial petition number 4, in item 29, my lord, I've received the instruction. But against the others, my lord, I'm still
What is the
awaiting.
name of the petitioner number?
That is Lavanya Gogoi.
Abuna Gogoi,
Lavanya Gogoi. That
In
she's
respect of
working. She's
Against the
working.
sanction. She was appointed against the sanction. For rest, my lord, I need some time, my lord.
How many petitioners are there? Different
There are
petitioners.
five, six.
In 29, there are 4.
There are 4.
So you give us the list
I'll,
Yes.
and indicate who these
Who-
names,
yes,
in which writ petition they're connected.
Yes. Yes.
Item 31, my lord.
And let him prepare the list. He
Yes,
shall take it
that,
and record it in the order.
yes.
Fix a date there.
The counsel for the parties, the counsel for the respondent submits that the process of identification, the
We want
process
to
of
repeat it,
verification and is still going on in respect of the claims of the writ petitioner. Some of the writ petitioners in the series are found to be working against sanctioned vacant posts. However, the process of verification is still underway. Mr. B. Kaushik, counsel appearing for the state submits, is permitted to place before the court the list of candidates whose names are found to be
Appointed
against the sanctioned vacant posts. And in the said list, the name should be marked against the corresponding writ petitions also. And the status of the respect of the other writ petitioners regarding their appointment in respect of as to whether their appointments were also made with regard to the sanctioned vacant posts. The petition respondent is permitted 3 weeks time, 4 weeks time, complete the instructions, release this entire bunch of cases after 4 weeks on a date to be fixed by the registry. Grateful.
Yes, can it be after 3 weeks? Because one of the petitioner is there in February.
By 3 weeks. Mr. MS. PA
28 hours, my lord.
and Mr. Aniban Das appeals for the writ petitions.
Yesterday.
28 August.
Yes, my lord.
28 August.
Oblige.
My lord, This is a series where the deputy commissioner took it upon himself to issue transfer orders in respect of the education department. Deputy Commissioner of Hojai. But be that as it may, my lord, I must indicate the current position. In this entire series, I am told that in item number 42, an affidavit has been filed by the education department, but not by the DC, who has actually issued the order. And we have filed a reply to this.
There was a circular or notification that
No, my lord,
DC will have,
so DC was given
uh,
to given the responsibility of execution of the act, provisions of the act. He took it upon himself to issue the orders. In fact, my lord, this issue has been dealt with by some other honorable courts, my lord, and it has been held that the DC does not have the jurisdiction. But be that as it may, my lord, I don't know what the
where are the judgments?
judgments are. Yes, sir. In WPC 400, para 15 onward, para 15, 16, and 19.
Yes, Mr. Kaushik.
Certainly, it's the appointments, in case if it is a regular appointment, that the director would be the appointing authority. And in this batch of writ petition, my lord, several petitioners were appointed by the SSA. In that case, my lord, it would be district.
For SSA.
So since the appointment,
In the cases that I appear, my lord, SSA is not the. We were regularly appointed under the.
In this writ petition 5235, where is the order?
I appear in the very next matter, my lord. If your lordship takes up that item number 33. The
No, while we are there in this matter, who appears in item number 32? You appear. Where is the order? Order of transfer?
My lord, the
This is a common order. This is a common order.
Yes, my lord. My lord, there was a guideline and plus the contention was to follow the ratio. Everything was, my lord, in violation. And ultimately, my lord, the section 8 of the Act of 20,
You're all teachers working under the,
my lord, under the education department, my lord.
not on the SSA.
At present, no, my lord, not on the SSA, my lord. And my lord, this issue where
Any counters to be filed by the state?
I think that it is the deputy commissioner who will have to justify, because since the peon orders are issued by the deputy commissioner.
No, there is a rules for deputy commissioner. Mr. Chaudhary has placed judgments by coordinate benches where there is a finding that DC is not empowered. Is it relevant for this?
I have to go through it, my lord, and if required, my lord, I have to file an affidavit on behalf of the district council.
my lord, from 2020,
These orders are under stay.
yes, sir. In some cases where they joined,
no stay.
there obviously was no stay.
Please examine the judgments and tell us.
Yes, my lord. I will examine the judgment, and if required, my lord, then I have to file an affidavit on behalf of the district council.
My lord, in both the cases where, in one case I handled, my lord, writ petition 400 of 2026. Alright, for few days, it went for, as a part heard. And opportunity was given to them, and ultimately the court could come to find that DC has got the only power to recommend in exigency. But there is no question of giving him the jurisdiction to issue the transfer order. And that is in violation of section 8 of the Act of 2020.
Mr. Sharma, if this order has settled this issue, then your affidavit is not going
Not
to improve
required,
the
then,
case.
then not required,
Yes.
then.
So please examine and tell us
My lord.
at 2 p.m. No,
The other day, my lord.
any other.
Wednesday?
Wednesday. Wednesday.
Let it be on a hearing day, in that case Thursday, will be convenient for it.
Yes, ma'am.
Thursday, there are already 54 matters for hearing.
Next Tuesday.
Next week.
You just have to go through the order and
My
tell
lord.
us whether it is on.
Any
or off.
other day, my lord, subject to convener of the.
My lord,
Then it is tomorrow itself.
Tomorrow.
Why not tomorrow?
Tomorrow at 2 as a fixed item. We can finish all the matters, my lord. In both the cases, the clear cut finding
Alright,
is
we'll
there.
give you 31st. 31st
Well.
July. Examine and tell us.
My-
These bunch of writ petitions challenge the orders passed by the. These are all collective orders,
Yes,
common orders.
transfer order.
Transfer orders are, my lord, 3-4 orders, but those who are common orders. From one order, 8 to 9 persons are over here.
Saying the orders passed by the Deputy Commissioner Hojai for all
Hojai,
district of Hojai,
Hojai.
whereby the writ petitioners were working under the, claimed to be working under the State Education Department and been transferred to various places. The primary challenge is that the state does not, DC does not have the power to issue the transfer orders, as they are employees of the Education Department and not under the Revenue Department. Mr. I. Chaudhary, Senior Counsel, assisted by Mr. A.K. Boruma, appearing in item number.
Several.
No, the first item that you said,
33.
33, has placed before the court two orders passed by coordinate benches in WPC 400 of 26 and WPC 343 of 26. Referring to the said judgments, Mr. Chaudhary submits that the question of whether the DC can issue transfer orders to employees in the education department have been answered by coordinate bench, allowing the claims of similar writ petitioners. Stop. Para Mr. D. Sharma, Learned State Council, additional senior government, appearing for this state, submits that you'd like to peruse these orders and apprise the court for the next date fixed. Considering the fact that the coordinate bench has already dealt upon this issue, the state is permitted to address the court on 31st of July, as agreed to by the Council for the Parties. Mr. B. Kaushik appears for the Education Department.
Petitioner doesn't want to pursue the matter. Item 62. He wants to withdraw the matter.
Mr. A.K. Borua appearing for the writ petitioner in WPC number 4763 of 2024, which is listed as item 62, submits that the writ petitioner does not wish to press the writ petition any further. He has these instructions. Accordingly, the writ petition so and so shall be dismissed as pressed. Interim orders, if any, stand vacated. Pending ayes, so dismissed.
The matters, the interim may be extended.
Interim orders, wherever issued, will continue till the next date.
Public.
Listing. Yes, respondents.
File the affidavit, have the copy of the affidavit with the finding.
Mr. M. Soikia for the petitioner, Mr. A.R. Tobildar appearing for the higher education. Submits that affidavit will be filed during the course of the day. Advance copy has already been served on the writ petitioner. Mr. H. Alia appears for Finance Department. You want to file Rejoinder, Mr. M. Soikia submits that he be granted 3 weeks time.
1 week's time.
1 week's time
Matter
to file rejoinder affidavit. Release this matter again after 2 weeks on a date to be fixed by the registry.
May I please? Section 11 petition for appointment of an arbitrator. Railways.
Any
Lordship.
objections filed?
Lordship, today we are filing the affidavit. Lordship, it may be taken up on Friday, Lordship.
M. Salih Sahibwala appears for the petitioner. The MS RDB Learned CBC appears for the respondent. Submits that the objection will be filed during the course of the day. Considering the submissions made, release this matter again on 12th of August. Yes, Mr. Ghosh.
It is against my lord, the quality of the suspension order. Lord. Now, my lord, for last order, my lord, the APR, my lord. Yeah. Otherwise, the facts is admitted, my.
So here we have supposed to file our affidavit, madam. Madam, we have pray for 1 week time, madam. Next week, any day, madam. I'll bring the up-to-date instruction.
Otherwise, my lord, he is retiring on my lord, December. My lord. No problem.
Mr. B.J. Ghosh appears for the petitioner. Mr.
PK Bora.
P.K. Bora, studying counsel. Secondary,
Elementary.
education. Prays for a week's time to complete his instruction regarding the status of the. Yes. You are under suspension. No show cause.
My lord, show cause was submitted beyond 90 days from the date of suspension. The law is settled, lord.
The suspension and the with regard as also with regard to the proceedings
Even my lord, the
initiated.
review was also done beyond 90 days.
Reply also
Everything.
filed, madam. Suppose reply.
That is the difference.
Let this matter be listed immediately after 2 weeks on a date to be fixed by the registry.
My date may be like, I pay your lordship, otherwise, lordship may kind. Just praying for you. Otherwise, I not mind. The actual circumstances of this case, I am just making.
17th August.
Blessed.
We have some the copy of the affidavit today also.
That's the way I have received that copy.
Mr. D. Barua appears for the petitioner. Mr. H.R. Tawaldar submits that copy of the affidavit will be filed today. Affidavit will be filed by tomorrow. Advance copy has already been served on the petition. The counsel petition submits that you'd like to file rejoinder.
Yes, my lord.
If required, therefore prays for 2 weeks for the term. Released again after 2 weeks on 21st August.
Oblige, your lord.
Lordship, your
Instruction was sought for much.
Lordship, yes, Lordship, here we are waiting for the response from the Inspector of Schools regarding the recommendation of the District Discussion Committee for the post of headmaster. This is not received, Lordship. A reminder letter has been sent, Lordship, on 24/7. We are waiting for that.
Last 2 occasions time is very short. Perhaps in other districts already it's over, lordship.
The state council, the council for the secondary education submits that the recommendations from the headmaster, the recommendations of the district
The
selection
District Selection
committee,
Committee, Lordship, for the post of
the post
headmaster.
of headmaster has not been received. Although a reminder letter has been issued
Lordship.
on 24/7,
Lordship.
2026. Stop. The counsel for the petition respondent therefore submits that further 3 weeks' time be granted to for awaiting the recommendations of the district selection committee and for necessary orders to be passed thereon on such receipt, upon receipt of such recommendations. Era counsel for the petitioner submits that undue delay has been caused, and in respect of the other districts, the headmasters have already been appointed.
Right.
So let the state call for the recommendations as for the district selection committee and apprise the court by the next date of listing, 24th August.
Much of it.
My lord, affidavit in opposition has not yet been filed, my lord. We need 1 week more time. 7. Affidavit for 1 week.
Further time is prayed for.
1 week, my lord, already sent.
Last time also it was paid. My client is suffering because he's around 24-5 years and is asking for the correction of the date of birth.
You're seeking what? Connection of?
Date of birth.
Correction of date of birth. You're employed under the board. You're employed under the board.
No,
No. Where are you employed?
no, I'm a student actually. I passed my MSc in chemistry 2024. My date of birth has been
Okay.
misprinted wrongly. Instead of 18/10/2000, it has been printed as 27/12/2000.
You're Mr.
Babul Kumar B.K. Borua.
Mr. B.K. Borua, APS for the writ petitioner, and Mr. D.K. Roy, APS for the secondary education, ASSEB. He submits, and Mr. P.P. Dotto for higher education,
Oh, 1. Secondary.
secondary education. Mr. Roy submits that how much time you want?
1 week.
1 week's time is required to obtain the instructions with regard to the prayer for correction of date of birth made by the writ petitioner. So let this matter therefore be listed after 1 week. On 10th of August. 10 August.
10 August. Right.
Cases. For the last occasion, they took also time for affidavit. Here, they are college employees, Lord, and they are covered by the Assam College Employees Provincialization Rules of 2010. Very commanding body is the disciplinary authority, they are the appointing authority. But in this case, the principal in charge has passed an order terminating the services in both these cases. In the first case, I think, 7. Their college employees, grade 3 and grade 4, and in the next case there are 2 lecturers. On the last occasion, they took time for affidavit. Nothing has been filed, and I don't think that any affidavit is necessary in the case also, because without notice, without anything, termination order is issued by the principal in charge.
Yes.
The main affidavit has to come from the college authority, because
Yeah, college authority.
because in the higher education department, there are 2 hours whereby engagement of contractual employee without having a sanctioned vacant post was barred. Even thereafter, the college authority engaged the petitioners.
No, they are not contractual. They are not contractual employees.
Contractual.
No. They are contractual. You see the appointment letters. See the appointment letters. Anyway, if they consent that, let them file affidavit or give records.
Weeks
Yes, rules for the college.
For the college.
Yes. What do you think?
345.
Your
Lordship,
Lordship will
just
see
one more
first case
Your Lordship, that,
15.
we have only received notice on behalf of the item number 77. On last date fix also, I requested a copy for item number 78. I have not received it till date.
He appeared and said,
Yes, I have not. Last date also I asked for a copy.
Please ask your assisting counsel to serve copies. May your Mr.
Chetri.
Mr. D.P. Chalia, Senior Counsel, assisted by. Your name?
Emerald.
M. Roy. The petitioners.
Yes,
Mr.
that's
S. Das, appearing. the
Higher Education Department, madam. I'm appearing for 1, 2, and 1 and 2, madam.
1 and 2, and Mr. T. Chetri appears for 3, 4, 5. He submits that extra copies have now been served of the respondents. Therefore, proper instructions have not been received. Counsel for the petitioner and advocate on record will ensure service of extra copies within 3 days, and matter be relisted again after 3 weeks, by which time the respondents are expected to apprise the court on the basis as to the reasons as to why the petitioners were terminated and whether any notices, etc., were issued prior to termination. After 3 weeks.
Lordship will fix it.
24th August.
Right.
Lordship, we have been directed to file an affidavit. File it. And otherwise, pleading is complete. The Lordship can take it up. The matter relates to provincialization of service.
Is there any private respondent?
No, you know, no problem.
It is submitted by the parties that the pleadings are exchanged. Will issue rule, fix it for hearing.
Lordship, he will retire by this.
The
On 13th, your Lordship, of August.
the matter be listed for admission hearing on 3rd of September.
Lordship.
3rd September.
Diploma. May I please, Lordship? This is a section 11 application. Readings are obtained, Lordship.
Lordship may peruse annexure 5, page 27.
Was it resolved?
Lordship, we had offered him the amount which he had asked for on 30th December 23 of amounting to.
No, pursuant to this order.
No,
27-7.
Lordship. No, Lordship. Lordship may appoint. Lordship may appoint.
11-6.
11.
Yes.
Lordship.
Heard counsel for parties, this application is filed seeking appointment of the arbitrators. Where is the agreement?
Page 18. Page 18, Lordship.
By way the agreement executed by and between the parties dated 21st of December 2016.
Yes.
What is this? Huh?
25th of December.
I don't know. Come to page number 12.
Lordship, it is 21st.
21st of December. The parties have agreed to constitute partnership and to carry out a business of the firm under the name and style within whose Brahmaputra floor mills. So, the said agreement also contained a clause of arbitration, at clause number 19, that provides that any disputes arising out of the deed of partnership or the partnership business shall be decided by arbitration and shall not ordinarily be dragged. So, it is submitted by the counsel to the petitioner that in the process of running their business, differences arose between the partners, between the petitioner and the respondents. Attempts were made to amicably settle the same. They could not be settled, and therefore the present application has been filed. So, the petitioner, where is your notice?
Page 55.
Petitioner had issued a notice dated 1/6.
Lordship.
Is it 1/6?
27/8/24, Lordship.
27/8/2024. Calling upon the respondents to appoint an arbitrator.
Page 59.
Calling upon them to nominate and appoint, calling upon them to concur on the nomination and appointment of the arbitrator named therein at para 11. So, the respondents having not responded to the notice issued by the petitioner under section 21, the present application has been filed for appointment. Objection has been filed by the respondents. Para objections have been filed stating that although attempts were made to amicably settle the issue, the same has not been resolved. Stop. Considering the issues involved, and this court is in the view that there is indeed an arbitration clause specified in the agreement dated so and so. Petitioner has also issued this under section 21 arbitration and conciliation act. Where there is a valid arbitration agreement, the parties are to be relegated their disputes for arbitration. The Have you raised any objection with regard to the nominated arbitrator?
Not with regard to the nominated arbitrator, but on the other aspects.
Huh?
On the other aspects, we had.
Since there is no objection raised by the respondent with regard to the nomination of the arbitrator mentioned in the notice dated so and so. Para 11, this court considers it appropriate to appoint the arbitrator nominated by the petitioner as the sole arbitrator.
Appointed from the panel of the.
We have not raised an objection.
Lordship, not in the affidavit.
Then, not raised an objection. Therefore, we asked you. You did not refer.
Not in the affidavit, we have not raised any
Then
objection.
if you have not, then we have not. The name is already there. Why should somebody else be appointed? It's only a question of appointment. Mr. Ajay Agarwal, CA, so and so address, is appointed as the arbitrator. Decide and resolve the disputes arising by and between the parties, arising out of the agreement dated so and so. This appointment will be confirmed pursuant to receipt of written declaration as specified under section 12(1) the Arbitration and Conciliation Act. Let a notice be issued. Let this order be communicated at the registry, Mr. So and so. Then file the application. File the declaration under section 12(1) of the Arbitration and Conciliation Act. Released after 4 weeks.
petitioner before the Lordship, because his salary has been withheld from April 2023 on the ground that his ELH certificate could not be verified because they had been seized by the Chief Minister Vigilance Fund, Vigilance Office.
It has been?
My lord, it has been seized by the Chief Minister Vigilance Cell. So 2023,
Yes.
April onward, my lord, we are getting the salary.
Lordship, here the council is involved and they ask us to verify it. Every time we try to verify, it's in the online database, Lordship. The number, issue number keeps on changing and the hard copies and everything are seized in the office of the Chief Minister Vigilance because there was a scam, Lordship, and that is still under investigation.
Who's for the
Autonomous copy.
Karbi Anglo?
Yes.
Yes.
You have no record of the application?
Our records has also been kept.
No record.
The also will see my appointment order at page 31. After completing the teacher's eligibility test, my lord, I was appointed as a science graduate teacher in the ME school.
No, but where is the impugned order?
No, there is no order, my lord. On the inquiry, they told that the verification could not be made because of the.
There is no order for stoppage of
No, my lord.
salary.
No orders as such.
Where?
Lordship, I will see order dated 19/6, my lord. This court has directed proper instruction regarding the current salary that has not been paid.
Any where have you stated in your pleadings?
My lord,
From which date your salary is stopped?
my lord, I have stated, my lord. Lordship will find paragraph 9, page 10, my lord. Operative person, page 11, second line.
Yes.
They have not disputed by certificate but issued by this SCRT. They have filed the affidavit only. Their stand is that all the documents have been seized by the CM Vigilance, my lord. Therefore, no record is available. And I am working, my lord, since then, my lord.
Where have you stated that you've not been released your salary?
Yes, my lord.
Which amendment?
My lord, paragraph 9, my lord.
Paragraph 9.
Page 11, lordship is the
11.
second line.
Second line. Stop.
From the month of April 2020. They have verbally told me that there is a discrepancy regarding the code number in the certificate, central code. They have not corrected it. And my salary has been.
And what have they stated in there? Who's filed the affidavit?
The SCRT as well as the Caribbean Autonomous Council, both have statement. They have filed the affidavit stating that all the records are in the SCRT. Therefore, they could not verify the records. Only that stand. I have filed the reply. Your lordship will find at page 86.
Who has stopped your salary?
Well, it is the salary is due by the Caribbean Autonomous Council.
You Karbi Anglong, have you filed your affidavit?
Yes, ma'am.
What have you stated here?
Only that, madam. That record is in the vigilance.
We have filed motion 7-3.
No, but if you can't verify, then why have you stopped the salary?
They are not disputing my certificate. Only that code number is there is some difficulty. As
But
per their statement.
there has to be some order for stoppage of salary. Any order passed?
No, man. I'm specifically.
Mr. Chaudhary?
No, Lordship, they have not passed any order, and the request that was made, every time we enter the number, the software has been corrupted in such a manner that it changes every time. And that's why, Lordship, we couldn't verify, and accordingly, we have reported the issue back to the council.
But how will it be verified? From where can it be verified? He has completed DLAD from where?
From my lord, under the depot basic training center.
Is it not possible to verify from the
Well,
center?
the Lordship will see the affidavit filed by the principal, my lord. I have replied there to my lord. I have annexed the certificate issued by the principal at page 86 of my reply. Even after they have said that it was seized in the year 2023, he has issued the certificate in the year 2024. 4/4/2024, page 86. Which is issued by the principal of the training center. In his affidavit, he says that the record was seized in the year 2023.
Who's for the principal?
Principal was represented by the Karbi.
Yes, Karbi Angan. His certificate is here.
Yes.
Authenticate it, Lordship. The original ones have been already submitted, Lordship, to the Superintendent of Police, Chief Minister, Special Vigilance Cell.
No, but who has ordered stoppage of salary without the verification? Uppati has ordered it. Please tell us at 2 p.m. Get your instructions, tell us. Who is ordered?
Well,
Lordship, can it be tomorrow,
Day after tomorrow.
Lordship?
left.
Release day after tomorrow, enabling these Karbi Angan and other women's standing on the instructions that is on the orders being passed. Respect to the writ petitioner for stoppage of his salary. As according to the petitioner, separate orders have been passed. Stopping salary of the writ petitioner. Released according.
Well, update.
Okay.
86.
Matter is regarding recovery of excess payment.
Recovered,
No, Your Lordship.
not recovered.
No. Our pension is on hold and the GPF amount is also on hold.
You are serving as what?
I have retired as headmaster, Your Lordship, on 3/31/3/25.
Headmaster belongs to which category
Grade
of
3, Your
post?
Lordship.
Grade 3.
Yes. As per law, Your Lordship. grade
Is there
3.
anything to suggest that he is responsible for royal of excess salary?
Here, my lord, 1st of January, a letter had been issued by the deputy inspector to the director of pension regarding waiver of the my lord excess dwell. And other my lord proposal has been submitted to the director of pension 1st of January regarding his pension.
Why is it taking 7 months?
Pension, director of pension maybe.
Who's for director of pension?
Lordship, the original service book is yet to be submitted by Lordship, by the department.
Why have you not written to them?
It is written, Lordship, on 9/7/2026.
The pension proposal of the writ petitioner, although stated to have been submitted by the respondent, by the parent department to the director of pension. MS is more than a counsel, government advocate for director of pension submits that the original service book has not been submitted by the parent department, for which requisition has been sought. Mr. Dora will apprise secondary education, elementary, will apprise the court as to whether all the necessary papers, including the service book in respect of the writ petitioner, has been served, have been sent along with the proposal to the Director of Pension. And if not, the necessary papers we send forthwith without any further delay. Placed again after 3 weeks. Interim order is continuing.
We are getting provisional pension.
Interim order passed early will continue. And the petitioner will also be granted these provisional pension.
Well, also, may I pray for a date because going on for some time.
28th of August.
Much obliged.
Bless.
But it is more on equitable relief. I was an LDA in a particular high school. My provincialization was set aside on counts of qualification and age. I lost in the writ appeal also, and it's okay. Now, my lord, the impugned order at page 60, whereby my lord, the Director of Secondary Education on 15/2/24 had directed the Inspector of Schools, Kachar District Circle, to hold the salary, my salary. There was no direction, although in the writ petition, but anyways, there was a direction to hold my salary. Now, from February till 31st of August, I retired. I kept working in the school. My provincialization was set aside, but I was not terminated. And page 49 onwards, we have annexed documents to show that we were continuously working in the school. Although, yes, my provincialization may be bad in law.
Pleadings exchanged.
Exchange. They are seeking, but the education department is on that. On this, at page 60, the second paragraph, if I may read below. Further, you are requested to submit a comprehensive report in the matter of Sarha Begum Laskar to District Scrutiny Committee as per provision of so-and-so Act. Even if this comes, taking this period from February till my retirement the 31st of August, because my provincialization is cancelled, interfered with, but I'm continuing. So I continued this period. So therefore, how they deal with it? That much. I'm on the legality of this, but whether they would release it or not is a temporary hold, pause button. End result is not a forfeiture, perhaps. Definitely, my provisionalized salary I would not get, but something I would get. We have annexed all the documents to show that we are continuing in service, and it is not their case, we are not continuing in service. On equitable relief, you know, that kind of thing. For these months, I'm paying the release of my salary.
Yes.
My affidavit. The Honorable Single Judge. Judgment was delivered on 16/6/2023. Your Lordship, kindly come to page 27. The order of provincialization was set aside with this honorable paragraph 39.
Provincialization
of the petitioner, present petitioner. And they preferred a
writ appeal.
Writ appeal, and in the division bench, the said order was upheld. So, upheld. The setting aside of the provincialization. Now, although it was set aside on 2023, but although the petitioner ought not to have been allowed to continue, but she continued. But from February 2025, since the director has written it to the secretary for deprovincialization, for cancelling her provincialization order, although it is not required because this honorable court has itself set aside. But therefore, my lord, from February, the salary was withheld.
But there will be a slight gap in what he's submitting below. So far as provincialization is concerned, it's conferring a benefit on an employee. Even if I have not provincialized, I am not terminated. I continue my service. My provincialization interfere with not my services. That is nobody's case, below. Only on these grounds for 6 months, February till August, whatever I'm entitled to, as per them, they may comprehensively consider the matter and release. That's all. And I concede my provincialization order was interfered with on grounds of qualification and age.
Well, the provincialization,
No, so if you're not provincialized,
we don't take the
then
responsibility of the salary.
the salary is to be paid by the managing company.
Managing company.
Absolutely. So therefore, under page 60, that's why I said it's not a government's term now. Since they have interfered, Director of Secondary Education, and said you are requested to submit comprehensive report. The report would ensure that this part would go by the managing committee, then I'll get the money. Only that part is under the clause.
Report will go to
If I may read page 60 below, the second paragraph. Further, you are also requested to submit comprehensive report in the matter of Saleha Begum Laskar to District Scrutiny Committee as per provision of Assam Education so and so and so 2018. So this the inspector of schools may kindly submit a report considering the factual background, the provision gone, continuing under the school, the committee would be. That is not forthcoming, and this pause button is there.
the court to direct the inspector to.
No, they would take the follow-up action. If they held by salary,
What has happened to the report? It has not come.
it's not come.
Report has not come.
No, in respect of Saleha Begum Laskar.
Who is
Now,
Saleh?
Saleha Begum Laskar is the one Millard who has put challenged the provincialization of this
Correct.
present petitioner.
Okay.
Now, pursuant to the direction of this honorable court, Millard, where this honorable court directed to take into consideration the for the purpose of provincialization of Saleha Begum Laskar. Now, District Scrutiny Committee has recommended the name of Saleha Begum Laskar for provincialization.
Not on that. The provincialization of the present writ petition was set aside.
Yes, that is
Writ
it.
appeal confirmed.
Confirm.
Now his claim is that okay, I'm set aside, but I'm still employed
So that
I was for this period.
for that period. What happened after that?
I retired.
He retired.
So his status as an employee has ended on 2023 after the judgment.
No, how
It is set aside. The provincialization order is set aside.
provincialization is set aside.
No, once when he was provincialized.
Provincialization setting aside means they're out of the list of provincialization.
Yes,
Somebody
he is
else
no
will
more
have to be there.
she is no more an employee of ours.
Exactly. But her termination is not issued by. Is there anything to say that if your provincialization is set aside, your services are terminated?
But since it was provincialized under the 2011 Act, when the school was provincialized, the
school was provincialized. Some teachers were there. Her name was included.
Yes,
Provincialized.
she got the
Some
benefit of
challenge-
provincialization.
Some challenge was made. Then the court said, yes, the challenge is correct. Provincialization interfered with. Therefore, the subsequent step of calling for reports in respect of the writ petitioner was challenged. But provincialization going away, does it mean the petitioner is terminated? How can you? You may seek recovery, that's a different issue. That this amount which has been paid, recovery, because it was unauthorized, etc., subject to same thing permitted. But she's no longer your responsibility. But
Yes.
The school authorities are there who's representing.
Headmaster, we had increased it, Mika.
Huh?
Headmaster, we had increased it.
You pay the salary,
That's all.
you pay the
School will
salary
pay.
for that period.
24.
Huh?
15 to 24. First,
Page number
page number 55.
65.
That's it. The execution order is of 15 June 2023. 2024.
No, your direction to this is to give us comprehensive report, etc. Is a different issue.
No, it's not a direction to
So
them.
you've been asked to hold on,
Go to the salary.
hold to the salary. Why have you asked for holding on to the salary?
No, Malad, it's a direction to the inspector of schools.
Uh,
Since the provincialization order has been set aside, we are no longer in a responsibility to pay the salary.
okay.
This provincialization order, Malad, by the provincialization, we take the responsibility of the financial implication.
We'll clarify this.
Lordship, grateful.
We'll clarify that this order will not affect the salary due to the petitioner from the management.
Natural. I'm so grateful.
Third, counsel to the parties, the petitioner is agreed by the non-release of salary for the period. Which
My lord.
period?
February 24
February 24.
till 31st of August 24.
February 24 to 31st of August 2024, during which time the petitioner had rendered her services as a teacher
in the LDA,
as an
lower
LDA.
division assistant,
In which school?
in Tarinipur High School,
Tarinipur High School in the district of
Kachar.
Kachar.
It will be junior assistant will be the proper term.
Stop.
Junior assistant.
Junior assistant. Stop. Petitioner services were provincialized as a junior assistant by order dated
20/08/2013.
20/08/2013. Stop. This order of provincialization of the services of the writ petitioner is assailed by one, what is her name?
Saleha
Begum.
Laskar.
Saleha Begum Laskar, who was also working as a LDA
One.
at the same institution. So this writ petition ultimately came to be allowed by judgment dated 16/6/23 passed in WPC so, whereby the following direction was issued by the court, page number
27.
page number 27, para 39. So you can say 37, 39. 37 and 39. There's no 38. This came to be assailed by the present writ petitioner in WA 100 of 2024, which also came to be dismissed and the order of the civil judge sustained. Further appeal was carried to the apex court. The learned senior counsel petitioner submits that notwithstanding the direction of the coordinate bench, which was upheld by the appellate court, interfering with the provincialization of the services of the writ petitioner, she is entitled to the salary from the management of the school for the period she has undergone services, being the period of February so and so to August 31st, 2024. So, submission of the senior counsel that while the petitioner's provincialization was interfered with, his services were not interfered with. So, the state council submits that in terms of the order passed by the coordinate bench, upheld by the apex court, the petitioner was not entitled to get salary. State, if the school management is required to pay the salary, they will do so as per the provision of stock. Mr. A. Chakraborty appearing for the school management as well as the headmaster refers to the order communication dated 15/2024 issued by the Director Secondary Education, Inspector of Schools, directing that the salary of the writ petitioner be kept on with immediate effect as per the order dated so and so passed in the previous so and so. So it is submitted that it is because of this communication, the direction issued by the director to the inspector that the salary is to bear. Having heard counsel for the party, the limited prayer of the writ petitioner is that salary for the period which she has rendered services from February 24 to August 31st be granted by the authority, namely the school management committee and the headmaster. There are a careful perusal of the judgment and order dated so and so passed in the petition so and so means that the provincialization of the writ petitioner was interfered with, and directions were issued to take steps for provincialization of the petitioner therein. This order came to be upheld by the writ so and so. As per the provisions of what is that act? Assam Venture School.
Yes. Assam
Venture School provincialization of services rules so and so. The state provincializes the services of the employees relating to a particular venture school as per the provisions specified under the Act and as per the charts, as per the particulars which are appended to the rules in the schedules. Stop. The effect of provincialization is that the employees are brought within the service of government and they become government servants and salaries and all service benefits are the government. So, till the time they are provincialized, the salaries are paid by the school management committee. So, while the petitioner's provincialization is put to challenge by the writ petitioner, while the present writ petition is provincialization is challenged by so and so, her writ petition being WP. Challenge made to the termination of service or seeking a direction for termination of service. Consequently, no such direction was issued by the court bench. The specific direction was that the court interfered with the provincialization of services of petition, present writ petition, which came to be upheld by the state appellate courts. The position under the rules would be that with effect from the date of the order passed by the court bench, petitioner is no longer a servant, government servant, and point of legal responsibility of the state authorities for payment of the salaries. However, if she is found to be working or rendering her services in the same concerned school, her salaries and other service benefits are required to be released by the school authority, as was done prior to her provincialization. So, since there is no specific direction for interference, for termination of the services of the communication dated 15/2/2024 issued by the Director's Secondary Education Inspector hold the salaries or withhold salary of the present writ petition with immediate effect in terms of the order dated so and so passed in WPC so and so, writ petition filed by so and so. It cannot, by any stretch of understanding, as per the provisions of the provincialization, be understood that the salary required to be paid by the school management for the services rendered by the petitioner for the period so and so to so and so are also required to be paid. Pursuant to the orders of the court, the petitioner's provincialization having been cancelled, she was no longer a government servant, and therefore the state was not required to release her any further payment from the government exchequer. So, but since her services were never terminated by the orders of the court, there was no occasion for the Director of Secondary Education issue any order which could be construed to be an order to the school authorities for withholding her salary, her capacity as so and so, not as a provincialized employee, but as an employee of the so and so institute. So, under such circumstances, this writ petition stands disposed of. It is directed that the respondent authorities, namely the school authorities, release her arreared pay and salary for the services rendered for so and so, and the communication dated so and so shall not be construed to be communication between the salaries by.
Yes, my lord. I'm appearing for the petitioner, my lord. Here, my lord, the petitioner was the principal of the Assam Engineering College. He was petitioner for almost, he was the principal for almost 17 years. In addition to that, he was the director of technical education for almost 9 years. What happened, my lord? In 2017, there were 11 polytechnics and 1 engineering college is to be made operational. The decision was taken by the government in 2016 in the budget decision before the assembly. So he was then the director of the technical education. So he was given the entire responsibility to ensure that the one college, engineering college, and 11 polytechnics to be made operational. So everything went on fine, my lord. There is no allegation, nothing. He was currently posted in the Assam Engineering College as a principal. The lordship will recall, my lord, in 2024, there was an unfortunate incident where 5 students unfortunately expired because of an accident, which was outside the college campus, my lord. My lord, immediately thereafter, my lord, the department took action and directed him to go on compulsory leave. So that order we have challenged, my lord. This court interfered, said compulsory leave you cannot. So that was set aside. Immediately thereafter, my lord, they suspended him and they issued a separate cause of show cause, saying that in 2017, when you did all this, you violated government circulars and rules during the recruitment. That is the gist, my lord. This is the second round of DP against him. And this is arising out of lordship. I will take your lordship straight away to the charges.
What was the punishment imposed?
My lord, reduction in rank. Reduction, major punishment, my lord. Reduction. He is the senior most educator, my lord, technical educator, my lord. Next
So
year,
what was his rank?
he was principal, my lord. He was principal of Assam Engineering College. He has been there. Before that, he was in Gauhati Engineering College as principal. Next year, he is retiring. He is the senior most principal, my lord. Senior most educator, my lord. Only because of this, my lord, incident, which he is not responsible, because they realized, my lord, when this court interfered, the first compulsory leave direction, they realized that in the first DP, they cannot do anything. Behind his back, they initiated the second one and suspended. That suspension order was also set aside by this court.
You filed an appeal?
Yes, I filed an appeal against now the decision, because in that writ petition, my lord, where the suspension was set aside, court directed that you finish the DP within 3 months. The direction was there. They did not do it. We filed a contempt. Now they have done it, my lord, and now we are challenging that order by which he has been found guilty of charges and he has been reduced. His rank has been reduced.
So appeal dismissed?
No, my lord. Appeal. There was no appeal, my lord. We straight came before this court. This is one of their objection, my lord. But then we are saying, this is a continuation of the previous, because twice this court has interfered. Same objection they have taken. Though this court never sent us back, my lord. And now the records have also been called, my lord. So therefore, my lord, I'm only saying, my lord, lordship may kindly take up, because the charge at page 52.
We'll take up the matter for hearing. Record. What about the records?
Records are here.
All right.
Records are here, my lord. Lordship, my lord, he's retiring next year, my lord. That was only
Next year, we are not even completed middle of this year. We are not saying that we'll hear the matter next year. We are not saying that.
It's a short matter. I'm only requesting, if it can be taken up, hardly it will take, I will take 15-20 minutes, my lord. My friend will take another 15-20 minutes.
No, but 15 minutes I can't dictate a judgment.
No, I'm sure that lordship may reserve the judgment. I'm not saying that's your lordship prerogative. That is not.
Your responsibility is to argue the matter.
Yes, absolutely. I agree with that.
My responsibility goes beyond.
Absolutely
right.
So if
We'll keep it in September. 3rd of September.
May I request, can it be next month, somewhere in middle of next month?
Let it be 3rd of September. It will require exhaustive hearing. Records are here.
3rd of September.
It's a Thursday.
Any day in August or 13th or 14th possible? If I leave it to your lordship.
13th, 14th not possible. Instead of 27th of August, we are posting it on 3rd of August. 27th of August, we are posting it on 3rd of September.
3rd of September. Very good.
3rd of September.
Yes. Records may be kept, because that was the direction.
Yeah, records will be kept.
Right. Pleadings are complete.
The earliest we can give you is
in August.
20 August.
Very well. Which is a Thursday.
But
yes.
3rd of August, there were no other matters fixed.
September, 3rd of September.
3rd of September.
When I'll leave it to your lordship, whichever way is best.
3rd of September.
Yes.
See by the government council. Considering the issues involved, that this matter will be still for hearing on 3rd of August, 3rd of September. the department records be retained by the council. 3rd September.
Very good. That's right.
Item 90.
You're Mr.
Rituraj Biswas.
R. Biswas and Mr.
Yes, yes.
S. Das and Mr. No. You're not there. Yes.
Collaborator has already filed it, and I am the first candidate.
Who is responding for? Principal.
Principal has said that in selection process, I have to first, I got highest mark. But some complaint has been filed again.
You file your affidavit. Weeks. Mr. D. Mount over the petitioner. We have higher education. And Mr. Respond number 4. Respond 4 is filed the affidavit. Department of Higher Education is prayed for. It's time to file the necessary affidavit. Release this matter immediately after 2 weeks or a date to be fixed by the registry.
In August, last of August or 1st of September.
Immediately after 2 weeks on a date.
Any date, Lordship.
To be fixed by the registry, yeah. We have indicated in the order.
All right.
Yes. Records received.
Yes, sir.
Oh, yes. Just complete.
What is no report found?
They have not appeared in the screening process.
Yes, Mr. Tully.
There, previous ones are correspondent. This appears to be the record they have shown of 17. But in my reply, I had stated the school at paragraph 5 of my reply. At page 107.
Yes.
All the petitioners have given the details of their documents clearly showing their appointment issued by the deputy inspector of school joining letter, copy of the challan of February 12, the service book opened by the petitioners. Go to show here states that I have been in the petition. Student will produce the copies of the service book as proof of their that they received salary from the state government at the time of hearing of the case. Then there's a separate paragraph so appeal court and appeal have categorically mentioned that I have also mentioned here below for the affidavit. I on behalf of the state wherein it was stated that more than 1,200 teachers appeared before the screening committee, but no minute of the meetings were available to justify the claim that these teachers belong to the legal category. Anyway, matter will be placed for hearing. Petition hearing below. Because in my petition, I have given the notices of all the persons who have
The records called for have been placed before
not the full record, but only regarding
relevant
two
reports.
persons.
Relevant reports. Right.
M.
M.
Right.
What? So, it should be according to on 13 September or
Admission.
13 September
Right.
for admission. The records which are placed before the court are returned back to the standing council to be retained and for being placed before the court at the time of hearing. Yes.
13th or 30th is Sunday.
Oh, sorry. 17th.
Fine. Yes. 7th.
Knowledge.
Matter pertains just principle of the teaching a high secondary school in the Bongai number. We have challenged the impugned order lawsuit whereby lawsuit allowed the inspector of the schools to act as in such principal authorized, depriving the petitioner who is the senior most teacher of the school by virtue of qualifications. They have filed the respondent have filed the affidavit lawsuit last occasion. They where lawsuit they have questions my MA degree which I have obtained in the year 2007 from Chhatrapati Shahuji Maharaj University, Kanpur. Kindly see their affidavit. They sought
No,
to
what is your prayer here?
appoint me as in charge principal of this.
Appoint you as an in-charge principal. Is there no principal there?
Yes, Lord. Right now, Lord, inspector of schools, what?
You are the senior most.
I am the senior most by virtue of qualification.
And the respondent questions your postgraduate degree.
Master degree. Master degree. Lord, kindly see page 40. Their
40?
affidavit.
43.
Respondent's affidavit and accept.
Yes.
They sought to lordship verify my degree, and in the lordship status, lordship kindly see the status and remarks.
Not verified.
Not verified. Remarks filled all correct mark sheet details passing here filled wrong.
That is was why Lordship my degree not yet verified, and they still questioning my degree, Lordship. I have.
So what is the meaning of the certificate?
Lordship, this is the government communication to the Fakhr Saudi Maharaj to ascertain my degree. Lordship.
No, this is not government. This is a reply by the university.
Yes, Lordship. That is Lordship. Government respondent to education department communicated to
So
the
you passing year you have incorrectly filled up. Passed out in which year?
2007.
So it is correctly filled up.
Lordship, we have not verified, Lordship.
Huh?
Respondent verified. This is the respondent's.
What is the meaning of the remark?
Yes, Lordship. They filled up the Lordship, that is passing yes, everything that the respondent.
Will you please read the remarks?
Yes.
Tell us what
Fill all correct mark sheet details, passing year filled wrong.
meaning. Passing year was filled wrong.
Yes.
Wrongly filled up.
Wrongly.
Now, what is the passing year referred to in the certificate at page 43?
2007.
2007.
My degree was also 2007.
2007.
Yes.
So where is the
roll number also correct? Question I have not.
Then
So
you
far
go
my-
and verify from the university why these details have not been correctly given to you. You file your representation before the university.
Then kindly allow me to file implement petition, Lordship.
File
Include the university, Lordship.
Counsel for the petitioner prays for granted for which time. File implement petition to the property. Sigaji
Sahuji
Maharaj
Maharaj.
University, Kanpur, from where the petitioner came. Mr. Sharma is for the state.
Lordship, list after 2 weeks.
Or 2 weeks.
Lord, may I pray for passing out in matter for the day, my Lord. Any other hearing they want to fix, my Lord. Under instruction of Mr. B. Gogoi, my Lord.
What is the matter?
My lord, this is the removal, my lord, terminations. This is an employee with SSA. And long back in 2012, after that, my lord, initially this Red Court has, Honorable Red Court has interfered, then directing them to follow the proceedings. Then second, my lord, he has reinstated, then second DP, and that was challenged, man. Here
DP was
also,
challenged.
my lord.
DP was challenged.
Yes, man. And then his removal from the service was challenged.
So DP also, second DP also imposed the same punishment.
Same punishment, same set of allegations. Everything is same. So now the vital question is now we have come with this court, for this honorable court, that this main witness on Nibaram Das is also made a private respondent A. He was not allowed to cross-examine and no documents were shown. And as allegation is that misappropriation and dereliction of duty and some others minor charges. So misappropriation, my lord, his post is DP and DP cannot handle this money. It comes to SMC, State Mission Commission, for construction of building in different LP schools.
Why it was pending for 12 years? I mean,
My lord,
sorry.
that is the question, my lord. He was out of service, my lord. It should be come to a logical end, or whatever may be. So we have given the reply, then everything is done. Our thing is basically that there is no findings. Facts is not there. Findings is only on advice of some advocate, additional advocate general, and no independent findings. And there is there's many allegations misappropriation they cannot prove because
This is 2018. So
yes, 2018 second litigation 99977 is 2012, and then 2018 second kind of this termination. So our case is that my inquiry reports and this substance they have required is not sufficient to prove the charges, all the charges. So this is basically this thing.
My lord, May I take my lord with me to page number 224, my lord? Paragraph that starts with under SR 203, my lord. The paragraph, my lord, the petitioner, my lord, contract agreement has already expired on 18/6/2011, my lord.
224.
224, my lord. The contract agreement between the petitioner and SSA already expired, my lord, on 18/6/2011, my lord. As he was in contractual employment, my lord, his service has to be renewed, my lord, from time to time.
He was terminated on which date?
My lord, the 6/8/2018.
18.
Yes.
Your contract terminated in 2000.
Well, my lord, and that plea was not discarded by this honorable court because stigma was done. They have brought some allegation, specific allegation, misapprehension. That should be 311 to protection. This was in earlier petition, my lord. There is a discussion, and this court says there's no. When you are bringing a charge, it should be proved. Yes, also 311 to as a civil
We'll take it up. Parties. Seventh August. Or 20 August. 20 August.
One